Just going to take me a minute. Oh, great. That's awesome. My head will be cut off because in order to get this in here properly, it's difficult for me to put my whole person in here. But I do use the board. I think it's helpful. I explain as I write. So first I want to start with the basics. Basics are critical. That's why they're called basics. There are 3 elements to a basic estate plan. Everyone should have these. I say just about without fail, everyone should have the 3 basic estate planning pieces. They are the will, right? We're going to start with the will. I hope everyone knows what a will is. It's the document that distributes your stuff. Can you guys see that, by the way?
Yes.
Okay, thanks, Ed. It's the document that distributes your assets to the people you care about when you want them to get it. All right? In a way that you want them to get it. So there's more than just, here, take my stuff. When I talk about a will, I talk about strategies, putting assets into trust for minor children, putting assets into trust for disabled children or disabled beneficiaries, things like that. It's more than just passing your assets on, but those are the basic elements. So with a will, if you have a will-based plan, you also have probate. Okay? Probate is the court process where the judge oversees the distribution of your assets according to the terms of your will. What does that mean? It means that you must file your will, your death certificate, an application to the court called a petition, waivers from all the people that are called distributees. Once those are all put in, the process begins. The person who's been nominated executor is appointed executor, and they can start doing their job. It is a process, and it also requires money, right? Because there is a filing fee with the court. So keep in mind that when you're using probate, there are monies to be paid to the court. Nothing you do with surrogate's court is free. Everything costs money. Every time you ask for assistance from the court, you have to pay a fee to them to get that assistance. Okay? All right. Probate is a good process. It's a wonderful process. It works well. The problem is that there is what's called a 7-month waiting period. That waiting period means that you must wait 7 months before an estate can be closed and distributed. Even if everything's done, you still have to wait. That's time to allow the creditors to file claims against the estate. Okay, so there's probate, there's filing fees, there's a 7-month waiting period, but the will ultimately will distribute the assets to the people that you've requested or that you've directed. Okay, that is done through the executor. I'm sure you've heard that term. The executor is a person who is appointed. That's their job. They also can get a commission. It's their fee. It's called a commission that is set by the state of New York as to the percentages that they're allowed to take. All right, not everyone takes it, but they are allowed to take it. Okay, so the will is very important. Everyone must have a will. And again, these are the basics. So I'm going to go to the second basic. I'm going to try to erase this. I just cleaned my board and I hope it'll erase nicely. And it will not. Second basic. Power of attorney. Okay, now I'm going to put a star next to this. I cannot stress to you how important the power of attorney is. It is vital that you have a power of attorney, because if you become incapacitated, there is no instructions, there is no power granted to anyone to make legal decisions for you or financial decisions for you. Unlike in the will situation, where if you don't have a will that you've drafted, New York State has already created a will for you and tells you where your assets will pass. There is no such power of attorney under the law. In addition, I'm going to talk about the healthcare proxy in a minute. The healthcare proxy itself has a statutory element that says if there is no healthcare proxy signed, we have appointed certain people to make those healthcare decisions for you. That's great. But with the power of attorney, there is no such person. Why is that important? Because if you become incapacitated and you don't have a power of attorney, no one can write checks for you, pay your bills, transfer your assets, protect your assets, get help from an attorney. Basically do anything in your behalf. Really, really important. So this is legal and financial decisions. Most of the time, this occurs when you are incapacitated. You are unable to make your own decisions, physically or mentally. You could be in the hospital, physically unable to pay your bills. Particularly during COVID. You guys may know that during COVID, it was very hard to have access to people that were in hospitals or nursing homes. And so getting them to sign checks was difficult. So you needed a power of attorney to write checks just to pay your bills until you got back home. Really important. Now, power of attorney is great, but there's one other element that's really important. It's called, right now, it's called the statutory gifts rider. The statutory gifts rider is that document that allows your agent, your power of attorney, to transfer assets out of your name. Why is that important? Because if you become incapacitated, and most particularly if you need to go to a nursing home, we need to be able to move assets out of your name if we want to protect them. If your family comes to me and says, hey, Rob, we want to be able to protect your assets. We want to be able to protect mom's assets. Just going into a nursing home, what do we do? My first question is, do you have a power of attorney? Does it have a gift rider? So if the answer is no, we are almost dead in the water. Okay, really difficult. So the gift rider is a must. Thankfully, I think the law is changing in about 2 weeks from today, and there will no longer be a statutory gifts rider. There will just be a gifting section on the power of attorney. That is still a must. Absolutely critical that that's on the power of attorney, because without it, we can't transfer assets out of your loved one's name or out of your name. Without that power, we can't protect assets. Okay, so really, really critical. As I said, New York doesn't have a solution for this statutorily. The only other solution is what's called a guardianship. So if you don't sign a power of attorney and you become incapacitated, you have a stroke, and you're unable to make decisions, what happens is your family has to file what's called a guardianship. And that goes to Supreme Court in New York State. That costs a lot of money. There's usually at least 2, maybe 3 lawyers involved in that process. They're all paid by your estate. So you could be lying in a bed in a hospital. Your family's going to court to have a guardian appointed for you. They could be arguing over it because they don't know who you wanted to be the guardian. And it costs, even in uncontested ones, $5,000 to $7,000. To get a power of attorney signed, $200 to $300. I think we know which one's better, because then you get to pick who you're going to have as your agent. You get to determine what instructions you have for them, and it costs a lot less money and a lot less time. So really, really, really important. Okay, I hope I'm clear about that. And as I always say when I do these things, if I impart nothing else to you today, I need to impart to you how important it is to get a power of attorney, and I ask that you please all get one. Okay. I'm going too fast. Tell me. I do have a lot of stuff I want to cover. I try to keep these to 45 minutes. They end up being an hour every time, but all right, number 3 is the healthcare proxy. Now, again, this is really important because it is your opportunity to tell the people that you care about, who you want to be in charge of your person, your decision-making for health reasons. All right. It's also important to impart information to the person you've appointed as your healthcare agent as to how you wish to be treated. For instance, at end of life, how do you want to be treated? Do you want to be kept alive in a coma? Do you want to be kept alive if you're brain dead? Do you want artificial nutrition, hydration, and do you want resuscitation? Do you want any of that stuff to keep you alive? And if so, for how long? It's important that you write it down so that when somebody picks up this piece of paper, this is what they're going to have. They're going to have this healthcare proxy. and they're gonna read this thing and they're gonna say, oh, that's what he or she wanted. It better darn well have the information on there to help them make the right decision. So they're not suffering trying to figure out what you wanted. So it's more important than people think. This is an easy one, and this one does not take place, does not become active until you're incapacitated. The power of attorney, on the other hand, we talked about, is good the minute you sign it. But the way you manage that is you control the document. You keep the document from anyone until they absolutely need it. Okay. What we do is we hold on to those most of the time. We tell the family to tell their kids, call us if something happens. So healthcare proxy, very important. What we do is we give you, if you do a power of attorney or healthcare proxy with us, we give you a cardboard tube. That healthcare proxy goes in your freezer at your home so that you always know where it is. And so if the EMTs come to your house, they will look on or in the freezer to find that. Very important that you've got that in a location that you can always grab and go, okay? So basics: will, healthcare proxy, power of attorney. Everybody should have those. When I say everybody, everybody who is married, has children, is over 25, any of that stuff, okay? So keep that in mind. I trust that you guys all know what those are and now understand how important they are. All right, now I want to talk about techniques a little bit, because estate planning is more than just a will, and the techniques matter. When I'm talking about techniques, I'm talking about ways that you give your assets to your family. It's not as simple as I said earlier, just giving it to them. I'm going to start by talking about wills and how we do things with wills. I'll incorporate some blended family questions because I think those are really important. Some of these will also apply to same-sex families. These elements to estate planning are really, really critical when we're talking about how to pass things on. So let's take a look. In this case, we have a husband and wife. These are wills. I draw them with little boxes, as little open boxes. So this is a will, and this is a will. This is husband, this is wife. I try not to be sexist, but I will use statistic probabilities, and I'm going to kill the husband first, okay? That's usually how we do it. In the most basic plan, what happens is they have a bunch of joint assets, house, investments perhaps, and then we have life insurance and IRAs. And so these assets go to the survivor. And again, life insurance would generally pass, and IRAs would generally pass to the survivor. So if husband dies first, everything automatically passes to wife in this scenario. Very little probate to do. Sometimes the husband owns something that he can't own jointly with the wife. Perhaps he owns a business, or he's got a practice of some kind, a professional practice, or he just has other interests that he owns that he cannot give or hasn't given joint ownership to. That would pass through the will. On a basic plan, everything would go to the spouse. Real easy, right? Easy plan. And then when spouse dies, let's say they have 2 children, the money would go, or the assets would pass to the children in trust. And generally speaking, we put it in trust till they're at least 25. Sometimes older, sometimes 30, sometimes 35. If one of them is disabled, then we put it in what's called a special needs trust, also known as an SNT, to protect them so that if they have benefits from the government, they don't lose those benefits by receiving an inheritance. This is really critical. All of our wills, every one of our wills has a special needs trust in it, just in case one of the beneficiaries is disabled. Because the fact is, if you today are fine and all your family is fine, you don't know that tomorrow one of them won't be disabled, or at your death one of them won't be disabled. So we always put it in there just in case. Really, really important. We also put minor trusts in all our wills because you don't know that at your death you won't have lost a child and their children will inherit their share, right? For instance, if this is a child who's over 25, what happens if they predecease you and it goes to your grandchildren? I see so many wills that don't account for the possibility that it gets down here. And if these people inherit, this needs to be in trust again till they're 25, right? This is important. Grandchildren, people under 18 or people at 18 are knuckleheads. I have an 18-year-old. Trust me. You got to be sure it goes into trust for them until they get a little bit later in life, a little bit more experience. Okay? Now, so this is a basic will plan. Pretty straightforward, I think, but I want to turn it up a notch. So let's erase this. Let's use the same will, and let's try something different. Let's say this guy's got life insurance, lots of life insurance. And let's say that this is a blended family. So he has one child, and she has two children from different spouses. Now, perhaps right away you can see that there's some challenges here, because if the husband leaves everything to his wife, it's very possible that the wife will leave everything to her two children and leave out the husband's first child. We are faced with this scenario repeatedly, almost certainly monthly, if not weekly. How do we accommodate the extra child or the children on both sides? Because this could occur too if the wife dies first. So there's a couple of ways to do it. Number one, when husband dies, we take life insurance and we put it in a trust. Instead of giving everything to the wife or the spouse, we put it in the trust. This is a trust where spouse is the beneficiary. Okay, so the spouse can have money from the trust, but at the spouse's death, this child inherits this money. So the spouse doesn't own this money. Spouse can't control this money. The spouse can receive payments of this, but it ends up with child number one. Then everything else that went to this spouse, the surviving spouse, goes to her two children. And that way we've covered everybody. We can do this with IRA money. Instead of life insurance, we can do it. So IRA money passes to the sole child, the single child here. There are a lot of techniques we can use to ensure that in a blended family situation, everybody inherits the way you guys want them to. The problem we face is there's no such thing as a pixie dust. We can't make this perfect. And if anyone tells you they can, it's impossible. There are a lot of techniques we can use, and there's better ways to do it. Trust me. Utilizing trusts, gifting life insurance or IRAs at death are just some of the techniques, but those are the best ones. So for our basic plans and our basic ways to protect assets, this is what we're going to use as what's called a testamentary trust. And two, in this case, let's say these people had all three children in common. If this were, let's say, $2 million in life insurance, we still might want to put it in trust here, because now we've got $2 million protected from creditors, from second marriages, right? Wife gets married a second time after husband dies. We got this money in this trust to make sure that when she dies, the three kids get the money instead of the new husband or the new husband's children. So there's a lot of reasons to consider using testamentary trusts at the death of the first spouse. All right? Questions? I know I'm going fast. I know it's confusing, but what I'm trying to get across is a general sense that there are techniques and ways to do this, rather than just saying, I give everything to my spouse, or I give everything to my spouse. There are things that we ought to consider if there are concerns or issues in your situation. I'm not going to say the word problems, because those aren't true. It's issues or concerns that we want to remedy using techniques. Okay? All right? Just so you're aware, I'm a big believer in life insurance. When you're young, you should have life insurance, term life insurance for your children and your spouse. As you get older, you should consider some kind of permanent life insurance as part of your long-term estate plan. There are many reasons to do it. There are many more reasons now. If I have time, I'll get into more of those reasons. I'm just making sure I take notes for things I want to talk about. Okay. So life insurance has re-become, if that's a word, a part of our estate planning techniques for a lot of reasons. And we'll talk about that a little bit. Okay. All right. So I'm going to erase this plan. Actually, I'm just going to go to the next page. I got a 2-pager here. Now, I'm going to turn it up a little bit, and I'm going to start talking about the next phase of estate planning, which is trusts. Trusts are very important because their use is multi-tiered, but also has, and it depends on your goals, but there's many good reasons to use a trust. For instance, if you have, let's say you have real estate, which of course is very common now, a house in New York and a house in Florida, or a condo in Florida. If you own real estate in another state and you die, we will have to probate your will here in New York and in Florida. That's 2 probates, 2 times the cost. You don't want to spend that kind of money. So whenever someone comes to me and they have real estate in multiple states, we always really start considering a trust, because what you're doing is pulling all that real estate out of probate and administering it here in my office rather than through the court system. It's much easier to do. So a trust does not require probate. A trust is a self-contained managed inheritance tool that we can use right here in the office. Okay, I'm going to talk to you a little bit about how trusts work. I'll start with what's called a revocable trust. So a revocable trust is an open box. We can put stuff in it, and I say you can put stuff in it, and you can take stuff out anytime you want. So you want to put things in the trust during your lifetime, because the goal is to administer this trust after you die with the stuff already in it. So the trust can actually take title to your house, to your investments, to your life insurance, to your annuity, even to your car. And those assets are now owned by the trust, so that when you die, you don't own them. So they are not administered through your will. They stay in the trust, and the trust then distributes them to your family. Okay? The nice thing about a revocable trust is it provides a lot of flexibility, and it's really helpful if you have a house in 2 different states. Allows you to put your money in here and take money out anytime you want without restrictions. It allows you to create a trust for your spouse when you die, like we talked about when I talked about the will, and for your children when you die. And I'll get into more detail in a second. A very handy tool. This is as I said, we use this a lot when we have clients with multiple houses in multiple states, blended families, same-sex couples with different families they want to leave stuff to if they don't have children. When you and your spouse or you and your significant other have different ultimate goals. So if your first goal is to take care of each other, that's great. If your second goal is spouse A wants to leave their stuff to their siblings and spouse B wants to leave it all to charity, you can each create your own revocable trust, takes care of each other while you're alive. When you're both gone, it distributes separately. And the surviving spouse can't change who receives it when he or she dies, so that you know that your assets are going to pass to the people or the institutions you care about. It's a really important technique if you've got differing goals among spouses or significant others. Okay, so it's a wonderful tool in that respect. Much better than a will, just easier to manage, and a better tool than a will. Okay, so this is a revocable trust. Very important to understand. It avoids probate, but does not protect your assets from the nursing home. So it is not an infrequent discussion I have with people when they come in and say, well, I've had this revocable trust. My stuff's been in here 10 years. It's protected from the nursing home. And I have to look at them and tell them, no, it's not. There's a certain attorney in Syracuse who does a lot of revocable trusts. And people constantly come in and say, well, my stuff's protected. And I always have to tell them it's not. And they're surprised by that. They think, well, it was in a trust that's protected. It's not. The revocable trust does not protect your assets. So let's talk about how you do protect your assets. Okay? Because there is a way to do it. There's 2 ways. You can give your stuff away, and that has a slight chance of protecting your assets. Or you can do this with it. Remember, if you give your assets away to somebody else, you lose control of them. And those assets become subject to their liabilities, their problems, their issues, their marriages, all that stuff. If, however, you decide to do something different, anyone want to guess what that is? Can you see it well enough? That is a safe. I know it's not well drawn, but this safe is our irrevocable trust. Okay? This is how I describe the trust to people who come in and see me, because it's a simple way of getting someone to understand what we're trying to create here. We want to create something where we want to protect these assets. So let me walk you through how it works. So with a trust, with an irrevocable trust, we normally put your house in there. Okay, important, we want to protect the house. We'll put investments, life insurance, annuities. Okay, we'll even put cash in there, cash or money, into the trust. There's a couple of very important rules with this trust you have to understand. Number one, once this is put in here, this is called principal. Principal cannot be distributed back to the grantor, back to the person who created the trust. So if you create this trust, we put your stuff in there, the trust cannot give money back to you. Yes, that is a concern for people. But let me finish. Hopefully I can make you feel a little bit better about that. Importantly, you can be the trustee. If you're the trustee, you control everything that goes on inside the safe. So inside the trust where your stuff is, you can control it. So how do you invest the money? Do you pay your life insurance premiums? Do you like annuities? Do you want to cash out the annuity and put it in the investment? Do you use the cash to put a new roof on the house? Okay? All things you can do inside the safe. What you can't do, again, is transfer the money outside the safe. You can, if you choose to, when you create the trust, reserve the right to income from the trust, which means dividends, interest, rent can all come out of the trust and go into your pocket. That's great, except the problem is that if you go into a nursing home, the nursing home gets that money. So you got to keep that in mind. That's a trade. If the assets are in the trust for 5 years, you have 100% protection from the nursing home. This 5 years has been 5 years for a long time. That could and likely will change. 7 years, 10 years, who knows? Anything's on the table. But that is important. But right now it's the 5 years. It's reasonably favorable to people who create trusts right now. Now, if you put all this stuff in the trust and you needed something out of the trust, you can give it to your family, your children, and they can give it back to you or spend it on you. That's legal. It's totally legitimate. That can happen. Now, when you create a good plan, there's certain things that stay outside of trust, particularly in irrevocable trust. First, IRAs cannot go into trust. And I'm going to circle back to this in a minute and talk about why that's an issue, why that's a particular issue right now. IRAs cannot go into trust because the law says they cannot. Your income doesn't go into trust. Your income is what you live on. So the income comes in every month, you spend it on your monthly needs, and generally comes in and goes out, right? And then we have your mad money, your fun money. And that money is the bucket that you keep and retain versus putting it in the trust that you think you're going to need to live on, to spend, to have fun with, to travel, to play golf, to whatever you want to do with it. And that is a very important piece. It also depends on how big this is and this is to determine how much mad money you want to keep out. Because in a perfect world, you're going to put what you can in the trust because you want to get the 5 years done so that stuff is safe. So what's happening now in 2021 that is important and significant? There's a couple of things. Number one, we're seeing a lot of people come in to us with millions of dollars in their IRAs. $1 million, $1.5 million, $2 million in retirement accounts. And it's only going to continue to grow as people start saving early and very hard at work. Young people are starting to get IRAs built very early. And these things, as you know, are growing like crazy. There's something like $30 trillion sitting in IRAs, 401ks, 403bs, waiting to be taxed. But They cannot go in the trust. So this is at risk. Now, if you go into a nursing home, let's say you have $1 million in IRA. If you go into a nursing home, then Medicaid cannot force you to spend the $1 million. What they can do is force you to take money out of there and put it in your income. And as it comes out of the IRA and goes into the income, your income goes up. So if you are already getting $6,000 a month, this would add probably another $4,000 a month to that, giving you $10,000 a month. From that, if you're married, $3,200 stays with the spouse at home, which means $6,800 will go to the nursing home. And while the current cost of a nursing home is almost $12,000, $6,800 is not inexpensive. It's better than 12, but it's not inexpensive. So how do we combat this situation? How do we protect assets when we have so much money in IRAs that I can't move into a trust? There's a couple of ways. The biggest way, though, as I said, I would talk about is life insurance. What we're trying to get people to do when they're young enough is to buy permanent life insurance, put it in the trust. What we're using the life insurance to do is offset this cost to the nursing home that could happen someday. So we might get a $200,000, $300,000 life insurance policy, put it in the trust, protect it. And that way, if they go into a nursing home, they're going to get paid back with the life insurance. In addition, the problem we have right now with long-term care insurance, which used to be a reasonable option, is that it's so expensive and so hard to get that life insurance is much better. Simply put, when I ask people about this, I ask them, okay, if you had to buy insurance that had about a 35% chance of paying off, or you were going to buy insurance that had about a 100% chance of paying off, which bet are you going to make? Well, everyone says, well, it's 100%, right? So this is long-term care insurance and this is life insurance. What's the difference? Well, the chance that you're going to use enough long-term care to pay yourself back is about 35%. The chance that you're going to die and collect on life insurance is somewhere around 100%. I don't know anyone that has escaped dying, but pretty clearly, this is a good bet. So when I'm talking about how do we insure a risk, because that's what insurance is, I'm going to insure a risk. The risk that I'm going to go into a nursing home, I often talk about life insurance because if you go into a nursing home and have to pay some money, we're going to pay yourself back with the life insurance. The problem with long-term care is if you die and haven't used it, it's gone. It goes away, it disappears. Life insurance pays out. That's the point. So I'm trying to get people to consider life insurance early enough that it's affordable. In addition, one of the problems we have with these large IRAs is that under the new law, IRAs now have to be paid out to beneficiaries other than spouses or disabled beneficiaries over a 10-year period. When it used to be that you could leave an IRA to one of your children and they could take it out over 20 or 30 years, and thereby reducing the taxes and allowing that to grow, now they have to do it over 10 years. It has substantially reduced the ability to leverage that money to grow. It has also substantially impacted how much taxes they'll have to pay. Because of the limited time they have to take more out, there's a much likelier chance that they will end up being bumped tax brackets and paying more in taxes, not just more physically in taxes, more numbers, but more percentage in taxes. And that's a problem. So what we're doing is using long-term or life insurance to offset that possibility. Again, buy life insurance, put it in the trust. So we're leveraging life insurance to protect against long-term care costs, income tax, and the possibility that the new administration is going to be charging us with a greater amount of capital gain tax. So I'll talk a little bit about capital gain tax. Even though some people consider it scarcely relevant, it becomes really relevant even for most middle class folks. Because what happens is if you buy your house or if you buy stock, let's say you pay $1 a share for some stock. and it's now worth $51 a share. The difference between the dollar and the 51 is called capital gain, right? I'm sure everyone's heard of that. But you don't pay the tax until you sell the stock. If you die owning the stock, or if you die and the stock's in this trust, you get what's called a stepped up basis. This is your new tax basis. So if you die and your children sell the stock the next day at $51, they pay zero tax. And our president has talked about getting rid of this stepped up basis and forcing you to pay tax regardless of when you get this money or get the stock or a house, things of that nature. So we're concerned a little bit about how this new tax regime is going to work. And again, we're going back to life insurance. How do we offset these taxes that are going to sneak up on us? Use life insurance. It's tax-free, it's cash. It offsets a lot of problems. Trust me. So again, consider life insurance or permanent life insurance as a part of a good estate plan right now for many reasons. Okay, so I want to erase this, and I want to go back to the trust for a minute. I talked about some of the reasons we use life insurance. I want to talk about this trust. The irrevocable trust, again, put the assets in it, we get past 5 years, you go into a nursing home, we apply for Medicaid. Medicaid doesn't even see these assets. They're gone. They disappear, and they can't count these as resources. So those are protected. Those will end up with your family. When you eventually pass away, this goes down. Let's say this person has 2 children, and they're going to treat them equally. The trust goes down, it creates a trust for each of the children. The reason we're creating trusts for the children is we want to protect the children from what we call the 5 Ds, the 5 dangers or the 5 Ds. Now, this is important because we're one of the few firms that automatically does this asset protection for your family. We think it's really important because, again, you don't know what position your children will be in when you die. So what we're doing is protecting them from divorce, disability, disease, death, and debt. So if they're in the middle of a divorce and this money's in this little box, in this little trust, that can't even be seen because they don't own that money. If they're disabled, as I said, we put it in a special needs trust. That money's protected so they don't lose their governmental benefits. Really important. If they're sick, they're running up medical bills. They've got creditors. They've got problems. Their health insurance isn't covering everything. We want the money in a trust so that when they get better, we can use that money later. If they die shortly after you, this is an issue that people don't understand, constantly don't understand. If you have a will that leaves your assets to your 3 children, or in this case to your 2 children, and this is just a will and it says they get it when I die, and one of the children passes 2 weeks after you, what happens? The assets have passed to that child already. So they pass down to the child here. The child is now deceased. The money then passes through their will. In that case, it probably goes to their spouse or who knows where, because you had no control over it. And using our trust, the money gets captured in this trust. Now, this trust has rules in it that says what happens if this person dies. This person dies, instead of it going to the spouse, okay, it doesn't do that. It goes down to the children, the grandchildren, and again, in trust for them. So what we've done is protected against the unforeseen death of this person after you die. If you have a will, I want you to go read it and see what it says. I'll bet you dollars to donuts it does not have that protection. It might say to my children per stirpes, or to my children equally, share and share alike, but it doesn't protect them if they die after you. Before you, yes, not after you. I know it's hard to understand because they die 2 weeks later, they haven't collected the money yet. It takes a lot longer than 2 weeks to get the money. So now the money follows their will. So be careful using a will and passing it on to your family, particularly if you're concerned about your son or daughter-in-law. How about that? So we're trying to protect against these 5Ds by protecting these children. And then, of course, we protect the grandchildren by putting in trust until they're a certain age. So we want to protect the assets here, here, and here. And again, blended family protection, we can ensure that the money, sometimes we'll use 2 trusts, one for each spouse, so that it goes down to where they want it to go. Or a trust that can't be changed to disinherit the deceased person's children. Really important. You have a trust that prevents the disinheritance. You can't do that with a will, or at least it's very hard to do that with a will. So this is a better tool if there's a blended family. If there's things that you want to accomplish that seem impossible, we always try to find a way to do it, or difficult anyway, not impossible. But there are challenges out there. Sometimes, as I said, we'll use the IRAs or the life insurance, give them to the first spouse's children at that spouse's death, and then everything else to the surviving spouse, using IRAs as a tool to offset in a blended family. I realize this is complicated, and again, I'm going fast. I don't mean to do that. What I mean to do is to give you enough information to start thinking about what's going on in your life, what your concerns are, what your goals are, what you're ultimately trying to accomplish, who you're trying to protect, if anybody. Do you have people you care about? Are you concerned about nursing home costs? Are you concerned about taxes? Are you concerned about income taxes, estate taxes, any of that stuff? People often ask about the estate tax issue. Well, right now, New York State has an exemption of 5.9+ million per person. So if you've got significantly less than $12 million, you're not too concerned. But if you have over 5 and less than 12, there is things you have to do in New York to protect your assets from taxes. It just doesn't happen by itself. As you may know, the government, both federal and state, have talked about scaling back the exemptions, certainly on the federal level. That raises some concerns with people, because people who, on the federal level, it's 11.4 million per person. That's 22.8 million for a family with no tax federally. That changes if the feds drop it back to 5 or 6 million. The change is dramatic, because the tax rate is somewhere around 40 to 50% of the dollars over that amount. So you have to be concerned, you have to pay attention. And I don't know what Cuomo is going to do in New York, but he could scale it back as well, thereby bringing more people back into the taxability, which is a big concern. If you do have more than $5 or $6 million, you should sit down and have a serious conversation about the taxes, because fixing it's not really hard, but not fixing it creates a big problem. So just keep that in mind, okay? Easy solution, but it has to be done right. Okay, so we talked about the basics. We talked about a revocable trust and how that works. We talked about an irrevocable trust, how this works. We talked about life insurance and where and how we would use that, why that's important. And what I want to talk about now is I want to spend a few minutes. I'm at the 45-minute mark, so if anyone's got a question or has to go, I understand. But I want to spend a minute, if I can indulge, if you will indulge me, on how Medicaid works, because this is really important and is terribly misunderstood. And from my perspective, if you have a better understanding of this, you're in a better position to help not only yourself or your family, but even your next door neighbor or your friend. Okay? So it is perhaps one of the most misunderstood things out there. So let me explain this a little bit. Medicaid is the governmental system that will assist in paying for the nursing home. It also provides health insurance for people who have very little money, as you know, very little income. But the Medicaid we're talking about is nursing home. So it's nursing home Medicaid. And I just want to spend a minute telling you how it works. First of all, if you're a married couple and you're applying for Medicaid, you are allowed to have about $75,000 plus $15,900 for the person in the nursing home. So about $90,000. You're allowed to have a home. a car, and funerals paid for. That's about it. That's not a lot of stuff. Most people nowadays are far above this at this point, and are looking and are concerned if something happens to one of them, how do we protect more assets than this? Well, there are techniques. First, I showed you how to the trust and how you do it 5 years ahead of time. If you haven't planned ahead, though, if you have a crisis on your hands, what do? Well, there are a number of exceptions to that. I don't have time to get into the exceptions to the limits I just showed you. Suffice to say, if you have someone who's disabled or someone who's lived with the parents for 2 years, there are some things, some tricks you can use. But if you're stuck, I'm going to explain some basic techniques and some ideas. Let's say someone comes to me and they have $300,000 of what we call excess resources. They have too much money. That's how much too much they have. How do we protect it? Maybe some of you have heard of the half a loaf or the 5-year look back, or things like that. I'm going to explain to you first. The 5-year look back, in its simplest terms, is a period of time that Medicaid looks at your records. They take your last 5 years of financial records, and they're looking in those records to see if you gave money away. So let me use this person as an example. Let's say they have $300,000 of excess resources, but within the 5-year period, they gave away $100,000. They gave their house to their kids. Okay? Thinking they were going to protect it and find out that they didn't. This gift is now a problem. This happens all the time. We have people come in and they've given money to their kids thinking there was going to be a good idea, that was going to protect it. Turns out to be a really bad idea because the kids don't have the money left and they can't give it back. That's a bad idea. In this case, let's say we had $400,000. We take this money, we transfer it to our trust. Now we have transferred $400,000. Well, we already gave the gift away, so that's gone. We transferred $300,000 into the trust. Okay? We have to, in exchange, have the trust pay, I'm going to call this mom. Mom's in the nursing home. Pay mom back roughly $10,000 a month for not 30 months, 20 months. About half of the 400,000 that was transferred. After the 20 months is up and we've spent about $200,000, we'll have protected the $100,000 gift and $100,000 of cash in the trust. So we protected the old gift and the $100,000 in the trust. We protect about half of the assets that were gifted or transferred during that 5-year period. This is a widely accepted technique. It is called a crisis plan. Someone's in a nursing home, they have resources or they made gifts. We got to move them and we got to protect them. It's relatively complicated, but it is a plan that works. We do it every day, literally. And there is a way to, this is the way you protect assets if someone goes in and is not prepared themselves for this. All too often we see people that come in and say, well, we didn't do anything. We told mom 5 years ago, we told her, she didn't do it. Now this is what we got. So I want you to understand, and what's important about this? What is really, really important about this? How can you do this? This goes back to my first beginning of this. You need a power of attorney to do all of this. You can't do this without a power of attorney. You can't just do this because you want to. You have to have the power of attorney with the gift writer that we talked about to make this happen, to create the gifts, to create the trust, to do the payback, to do all of that. It has to happen that way. All right. It is complicated. There's a lot to it. I'm trying to keep it simple and understandable, but it's important that you understand there are techniques you can use. Again, all the time I have people come in here and say, I didn't know you could do anything. And I said, well, we advertise on the radio, on television. I do webinars. I advertise in the paper, everywhere I can to tell people that there are things you can do. So it's important that you pass this along so that people understand. Okay. Now, And you guys have been good. You've been silent. I'm happy to answer any questions. I don't think anyone typed anything, but let me check. No. Does anyone have any questions? Things they want to hear about, things you want me to explain? I'm happy to get a little clearer on anything if you got it. Don't be afraid. It's your time. It's not mine. Okay. All right. No questions? All right. I much prefer to do these in a room with people. I think now that we're at the tail end of COVID, hopefully, we are not wearing masks in our office now for those people who are vaccinated. We may be doing some of these live. And once we're in the room together, we get a lot more feedback, a lot more questions. Obviously, it's more entertaining because I interact with people. I pick on you, you pick on me. It's a lot more fun. So I want to thank you guys for coming. Also, I want to say that obviously the reason we do these is not only to provide information to you, but we're always attempting to get new clients, so that's part of it. But I will be happy to answer any questions for anyone who wants to email me. That is my, can you read that? rkh@hiltonlawny.com is my email if you have questions. Please don't hesitate. Please don't hesitate to call 624-9600. We'd love to have you. We'd love to meet with you. The first meeting is no charge, of course. And at that first meeting, what I do is I take information. I go over your information. I confirm your information, your assets, your family, all that stuff, your goals, your concerns, your issues. And then I start to formulate a plan for you based on all of that. And it's the first step in creating a plan. I also generally will give you the price of the plan that day. And I say generally, yes, I do give you the price. The only sometimes I can't because there are things that even you don't know that you need to get me. But most of the time I give you a price that day so you know what you're getting into. All our plans, anyone who does a trust with us, and this is really important, includes what's called funding. Most of our colleagues around town don't do the funding part. Funding is critical. Funding is where we put the assets in the trust. If you're going to do a trust, the assets have to get in there. If you don't spend the time to put them in there, there's no point in doing the trust. This is really, really important. That is part of our fee up front, and we tell you that. So we tell you what it includes and how it works. We do the work to get the assets in the trust. We fill out the forms, we do instructions, we do everything for all the assets. So I hope that's helpful. Very complete. We do a lot of follow-up meetings to make sure it actually got done. Okay. So just briefly, by way of process, you call, we schedule a meeting, we send you a packet to fill out, you bring it in. We do the meeting. I describe the plan on the board. After I've taken your information, we establish the price. And then from there, I give you homework and we start the process. So again, depends on if you're just doing wills, if that's all you need, you have young children and you're still young yourself, we try to keep it very affordable. We also try to keep the process relatively compact because I understand that you're very busy at work and finding time to come and spend hours sitting with me is difficult. We still also do meetings by Zoom, by FaceTime, any of that stuff in case you need to do it from your home or from work, we can do that. I have a couple doctors that meet with me on breaks while they're at lunch. So it works much better so that we can use up our time and use it time wisely. Okay. So I appreciate your time tonight. Again, email or call, happy to have you. First meeting's free, as I said. If there's anything I can answer, if you're afraid to ask now, please feel free to call and I'd be happy to talk to you. Okay. Thanks everybody for coming. I did that in just about 56 minutes. I hope that's okay. You guys have a nice night. Enjoy your summer. And I look forward to hopefully meeting you guys someday. Thank you. Have a nice night.